All right, excellent. So thank you all so much for coming to this webinar that is co-organized by Hilarity for Charity, CareCopilot, and the law offices of Vlad Portnoy. My name is Alyse Dunn, and I am the founder and CEO of CareCopilot, which is a new organization that Hilarity for Charity has partnered with to provide people in the Hilarity for Charity community with some free services. And in short, my team makes the calls, sends the emails, and does all of the other admin when you're taking care of an aging loved one. And you get all of those services for free if you are a part of the Hilarity for Charity community. So I'll put a link in the chat with more information about that if you would like some help filling out those Medicaid forms, calling and making those doctor's appointments, and more. But the whole topic of this presentation is on different documents that you need if you are taking care of an aging loved one. And that is where Vlad is one of the experts. I know that he's very modest, so he might disagree with the word expert, but I would certainly consider him one. And to provide you with a little bit of background on Vlad, Vlad Portnoy is the attorney and founder of the law offices of Vlad Portnoy, also known as New York Wills and Estates. He is the managing attorney. The firm has two offices, one in Midtown Manhattan in New York City and another in Hackensack, New Jersey. The firm's practice areas include wills, trusts, estate planning, special needs planning, and elder law, including Medicaid planning and guardianships. Vlad Portnoy is a native Russian speaker, and he's been certified by the New York State court system as a Russian-speaking court translator. Vlad is a member of the Elder Law and Trusts and Estates sections of the New York State Bar Association, the New Jersey Bar Association, a wide variety of other bar associations. There's a long list, so I won't list all of them, but Vlad does frequent lectures on estate planning and elder law, so he is not new to presentations like this. And with that, just to sort of reiterate, Vlad is admitted to the New York and New Jersey bar, just those two states. So everything that he shares is a very general overview. So just keep that in mind because the laws in your state might vary. So with that, I will kick it over to you, Vlad.
Thank you so much, Alyse. Thank you. You're very kind. I really appreciate it. So, hi everyone. This is our presentation on the documents. As Alyse pointed out, this is not the legal advice because I cannot give legal advice outside of New York and New Jersey, especially if I don't know your particular situation. So hopefully this presentation will kind of make you think about what needs to be done and consult your local elder law and estate planning attorney for more information and immediate help. With that in mind, I will scroll to our next presentation. So to our next slide. So we do this because why do we do this? We do this because we trying to help everybody, and we do guardianships also when no documents are in place, but we'll touch upon them a little later. But just understand that it's better to have the documents now, even if you don't think you need them, rather than need them and not be able to execute them, because there's such a thing as a requisite mental capacity for the person who is signing the documents, and sometimes it's just too late, especially for people who are caregivers to the elderly, to their elderly aging parents or grandparents. This is a pressing issue. So we do this so we can preserve the legacy of those people and give them the respect that they deserve during their lifetime and after their passing. We do not want the family fighting over proverbial casket. That is what we're trying to avoid every day. We're also trying to help everyone understand and be keen to the signs of aging, of maybe a decline in mental capacity that will definitely and we're trying to educate everyone about that so you can actually see those signs and act accordingly and not let any time pass and maybe accidentally, unwittingly, let something slip through your fingers. So this is general legacy, but really, and we're trying to preserve the assets so they're not wasted, and we're trying to help everyone who is in need currently. What we do is called estate planning. There's elder law used to be part of the estate planning. Now it's kind of its own animal, but it all stems from one specific term. What's an estate? An estate is everything that you own at the time of your death. Really, it's that simple. Anything that a person owns that you need court's permission to transfer to other people is within your estate. The most notable parts of the estate are real property, wherever situated. If you're in New York, for example, it could be in New York, but you might also have a summer cottage in Florida or Poconos or in California. And it gets a lot more complicated if it's in France. But that is especially if it's in another jurisdiction. If it's in another state, that's already another jurisdiction, but especially if it's outside of the country, you absolutely need to speak with a professional. There's a tangible property that is something that is tangible, like cars or things of that nature that you can maybe it's a set of spoons that belong to your grandma that's very important to you. And even though it doesn't have monetary value, it has sentimental value, and it might spark a family feud, which you'd want to avoid. There's an intangible property, and that is bank accounts, investment accounts, and things like that. Now, you have to remember that each type of an asset, even though you might say, oh, mom has $100,000, it's not necessarily true, because if mom has $30,000 in checking account and then $30,000 in investments and then another 40 in retirement accounts like an IRA or 401k, they will be treated differently if she passed, and even more so under different regimes of every state, and even more so if she was on Medicaid, because Medicaid has something that's called estate recovery, where at someone's passing, they may be able to come in and collect against those assets for all the services they've provided. You may have heard the scare tactics, something like, oh my God, when you die, the government will come in and take everything. That is not the case. There's no one big bad government. There's agencies providing services. So if someone has a house for $700,000 and without proper planning during their lifetime, they racked up a bill of $500,000, Medicaid is entitled to those $500,000, and then the remainder goes to the family. It's not like Medicaid's going to just wipe out what you have. However, if the house is 700 and the services were extended for $1 million, Medicaid's not likely going, they might, but they're not likely going to go after the beneficiaries, but they are going to wipe out what they can because they're permitted under the law. So you have to keep all of that in mind when you're taking care of an aging loved one. Especially caution that you absolutely have to look for the signs of dementia, because if they already have a full-blown dementia, none of these documents can be signed by them anymore. That window's closed. You might consider guardianship, which again, at a later date. But if there's an onset, or if there's anything that you still have the requisite mental capacity, you're highly advised to speak with your attorney as soon as possible. What's a will? Everybody heard a term will, also known as last will and testament. Now, there's a common misconception. A lot of clients come in and they say, we want a living will. And we know they mean a will. They don't know they mean a will, because the reality is a living will is actually a separate document, and that's an end-of-life document that basically gives directions as to your wishes for your burial or organ donation. the will that we want, where we want to transfer our assets and our legacy to the next of kin or whoever we have that we care for, that's called last will and testament, and it is physically our last will. So a will is a legal. You can read the description here on the screen. That the idea of a will, and a lot of clients come in and they say, I don't know if I need a will or do I need a trust. The reality is that it's not either or question, it's an and question. You may just need a will, or you may need a will and a trust. They're not mutually exclusive because they work differently. A will controls what you have at death. That, as I said, you absolutely need court's involvement to transfer. For example, mom is widowed and she has a house, and she's the only owner on the deed. If she passed, there's no owner. And under certain doctrines, you can bypass the will and you can transfer, but we're talking very general here. And those are maybe only specific to New York. But in general, that is her asset at death. So what you would have to do is bring her will to court, to surrogate's court. In many states, it's called probate court. But here in New York, it's called surrogate's court. All of those courts are pretty much surrogate's courts, because there's a difference between a probate and administration. A probate is when you have a will, and administration is when you don't, and you let the government dictate how your assets are going to be split among the beneficiaries, which is not what you want in a lot of times, because part of your legacy might go to people you don't intend to, but that's the law. So there's a probate department and administration department. So in New York, it's called surrogate's court, but in other states, or for simplicity's sake, it's just called probate court. It's the same court. And the will must be probated. That means that you bring the will and a death certificate and a whole bunch of other documents to court, and you ask the court to appoint you as a designated executor, fiduciary, under the will. It may say something like, mom's will says mom has 2 children, and it says oldest child as a primary executor and the youngest child as the secondary or successor executor, if the primary cannot act, or it may be that the 2 can act together. Or it may be that one is in and one is not even close because the relationship was sour, or both are out because for whatever reason, and a family friend is going to be the executor. This is why you want to memorialize all of your wishes on paper and sign it when no parties that were left behind or left out can contest this document, saying that you didn't have requisite mental capacity, or you were under duress or subject to fraud. So the will be probated. It takes a long time. That's why, and especially it depends on the county in each state, and it depends on the state. New York City takes the lead on the longest amount of time in New York City counties of probating the will in general. Administration takes even longer, and other counties outside of New York City and other states, depending on each county, because each surrogate's court is per county, they may vary in the way in the time that they process, but it definitely takes several months for the whole process. In New York City, it may take 1, 2, 3, and more years. So you kind of want to also be mindful of that, depending on where you live. And then when you get appointed, so while this appointment process takes place, the court wants to make sure that even if you're in the documents and you're appointed executor, you are not a minor, a convicted felon, or suffering from mental defect that will preclude you from faithfully carrying out your duties. They also want to make sure you're not the culprit that hastened the death of this individual. So the court doesn't want to make really fast decisions on that. But eventually, when you get appointed as an executor of the will, this gives you the right to now contact all of the parties that hold in the assets, like this is now you can change the deed from mom's name to the estate name, and then eventually to distribute it to beneficiaries. This gives you the right to contact the banks where she had bank accounts and collect all of the money, which is called marshaling the assets. You open an estate account, you put all the money in, and then you deal with creditors first, and then at least in New York and New Jersey, and then you pay out the beneficiaries what's left. Again, tying into the Medicaid discussion or the IRS if they owe taxes, you do not distribute the money once you get appointed and got your hands on it, because you cannot defraud the creditors. You must pay the creditors. And Medicaid and the IRS are your biggest creditors, followed probably by the hospitals. If someone goes in, the bills of last illness may be in tens of thousands, even hundreds. And between all of that, and then there's going to be other parties, potentially there's going to be credit cards and things of that nature. So you cannot defraud them because the court appointed you. So you're now working technically for the court, or at least with the court's permission. So this is a supervised process, which is why planning is very important, where you can address those things before anything happens like this, and you're kind of caught unaware. So why should everybody have a will? There's a lot of issues that we can discuss forever and ever, but one of them is having anything, will or trust, but again, will being the starting point, is you have to make your wishes known. If you have 3 kids and you don't get along with one of them and you want to cut them out, then that is where you make it known. If you want to give, for example, you have 2 sons and you have 2 different Rolex watches that you just want one of them to have, each of them to have, then you have to specify which one. You don't want them to go, oh, I always wanted to have the Submariner, you have the other one. Even those things, there's years of like family history that can easily lead to bad blood. You want to put this, and it's very simple. It's called specific bequest. You can easily do this. You may have minors as beneficiaries. A lot of young families with kids come to us and they say, do we even need a will? We don't have money. We're whatever, 27, 33, 45, whatever the case may be. We're young, we don't have any savings. And the question is, do you have kids? Well, yeah, that's why we're here. How old are the kids? Well, they're 2 and 4. Okay, well, then they need the will. And even if you have no money, maybe by the time you passed in, God knows, 100 years, you'll have a lot of money, which obviously we wish that you all have. But at this time, you want to have a guardian appointed if both parents passed. A very little known fact is that the assumption is, well, I'm the parent, so I'm going to be automatically a guardian. And the truth is that that's not the case. At least in New York, as a biological parent of a child, you are their guardian of a person until their age of 18, which means you can take them to the doctor. But if they inherited $1 million from a favorite aunt in another state or another country, you're not automatically going to control that money. You still have to go to court and be appointed as a guardian of a property under the court supervision, and you become co-guardian with the child. And that and until they're 18, the court will supervise every penny you spend on them. As a matter of fact, you can't spend anything unless you go to court, you petition the court to allow you to spend specific amount of money for a specific activity, and let the court decide if they're going to authorize that or not. At 18, a person is no longer a minor, and the court has no problem of them using the money however they want to use the money. But so in a will, all of those provisions, you want to make sure that if you are concerned about someone who's a minor, you appoint a guardian, and that guardian has clear rules of what they would do with the money and how they can act for the benefit of the child. Similar logic goes for the beneficiaries with special needs. If a child is autistic or schizophrenic, bipolar, or anything like that, and they are on Medicaid and will probably be on Medicaid always, it's prudent to not give them cash outright, because that's, you just basically going to jeopardize their benefits, because now they have cash. So, and then they would have to, once the cash runs out, they will reapply. So there is this very specific techniques that you can utilize for special needs planning, that the child does not deplete these funds and also does not stop receiving the benefits, which is probably the most important when you have someone who's a minor with special needs or elderly and they're using services like Medicaid. What is a trust? In a nutshell, a trust is a contract between someone who's a grantor, who is a settlor, who is basically like a promoter of a company. It's someone putting the whole thing in motion, and the trustee, who is like a director of that corporation for the benefit of a beneficiary, someone else, a third party. And it could mean anything. So you have three actors. So sometimes, and we're just going to touch upon this in a few minutes, but the trust can be revocable or irrevocable, and sometimes they serve the same purpose and sometimes they serve different purposes. For every, and this is why you need to speak with your local professional who understands estate planning and especially Medicaid in your state, that will be able to advise if you need the trust and what kind of trust you would need. The difference between a trust is a will is a public document, and to probate the will, it takes time, probably takes money, and it's a and you need court's appointment. A trust, you don't need any of that, because a trust is a private entity. It's not published anywhere, and the beneficiaries can get the assets upon certain conditions, like a passing of the grantor, pretty much as fast as you can get to a checkbook and write a check. So, but the caveat here is the trust only controls what you put in it. So the difference, for example, let me give you an example. If you reside in New York where you own a house, but you also have upstate New York, you have a cabin, and you fund your cabin into the trust. Upon your passing, the will control the house, because that's in your name, and it will go through the entire probate, and it will be open to claims of creditors. A cabin in the woods, because it was in a trust, will just go straight to beneficiaries and will be protected from the creditors. So this is why trusts are very, very advised. Now you might say, well, why do I need the trust? Why do I need to spend money on some paper when I can just have a relative or my best friend that I trust wholeheartedly to hold it in their name and pass it to my kids when I die? Well, the problem is, what if they pass first? Now it's part of their estate. It's completely out of your estate. Your life, your house now belongs to that family, and you can't go back and to court and make an argument that, oh, they were just holding it for me, because you're literally admitting fraud on record. You don't want any of that. It's very easily addressed. Why consider a trust? As I said, you avoid probate. The distribution is almost immediate, and there's no time limits. You avoid public knowledge. This is the wills are published. They're public documents. You can go to court and you can just see the will in the closed circuit. And now that you can even see that online. And a lot of people don't want that. Literally, they just don't want that. And the will does not help you with things like Medicaid planning and a lot of tax planning strategies, because again, there's such a thing as a state recovery, and the creditors will come in. So if you want to plan for tax strategies or Medicaid planning, you want to take care of that outside of the will, outside of the public knowledge, and outside of the reach of the creditors. But you want to do it properly and legally and very timely. Two types of trusts. This is a very general overview, because there's revocable and irrevocable. And in terms of the trusts, remember we touched upon that there's three players. There's a grantor, trustee, and beneficiary. The grantor makes a contract with the trustee for the benefit of the beneficiary, and both of these trusts, irrevocable and revocable, serve the same purpose. Whatever is in them will bypass probate. That's pretty much their entire point. However, in terms of revocable trust, that's where all of your benefits stop. Because as you can see by the definition, revocable is something that you can revoke or amend, which means it is still under your control, which means whatever is under your control can be reached by creditors. If you have a bank account that you're the sole owner of and you get sued and you lose, you can't say, oh, it's out of my reach and it's in the bank account. Well, can you reach it for you? Yes, then you can reach it for us. Irrevocable trust is, by definition, something where you make a one-time gift and it's fully out of your control and ownership. This is how you are able to get the asset protection. So revocable trust, usually we don't talk about revocable trust in terms of different types and permutations because it's just a general overview. It's like a glorified will. Actually, it's called will substitute. You still have a will, but the revocable trust kind of acts as a will and becomes irrevocable upon your death. So it looks something like this. Grantor, person A, is making a contract with the trustee, person A, for the benefit of person A as a beneficiary. So it's all you everywhere. And you can utilize anything that's in there. You can put the house in, take the house out, use any money for yourself or anyone else, just like you can do it now. But because you have this broad, unlimited 100% discretion and ownership, the creditors can reach. So just having the assets in a trust is not enough. In terms of irrevocable, you as a grantor make contract with someone who is a trustee, who is not you, for the benefit of someone who's a beneficiary who's also not you. And usually you would put the assets in there that are something that's you're not gonna fidget with a lot. For example, you would, if you have a primary residence where you will continue to reside while you're receiving a Medicaid benefits, you can put the residence in there and say it's out of my reach. My adult children as my trustees will now manage it for the benefit of my adult children upon my passing. Remember, though, it's not always that easy because there's a look-back period for Medicaid recipients. So you always, in your state, you have to check for community Medicaid, which is the regular one where you live in home and you get a home attendant. There's a certain look-back period where it may be too late for you to do something. And there's a nursing home Medicaid, which is a lot more stringent because it costs a lot more money to Medicaid. And as far as I know, and definitely in New York and New Jersey and many other states, if not all states, it's 5 years, 5-year look back. So it's not enough to wait until someone with dementia is in such a bad shape that pretty much within the medical diagnosis, they're going to be in a nursing home within the next year or two. It's probably too late. You can still try, but the state can definitely reach in and make an argument that now it's theirs because it's within the look back period. So that's the trust in a nutshell. And for Medicaid planning, for someone with dementia or someone who is applying for Medicaid, we usually use specific type of Medicaid irrevocable trust. Irrevocable trusts have a plethora of different types and variations. They can be utilized for public benefits, for tax purposes, for asset protection. So there's a lot of different names, but usually they, one way or the other, they're somehow irrevocable. Additional documents that you need that we usually do as a packet with the will is power of attorney, living will, and a healthcare proxy. Power of attorney is everything that's not medical. I'm specifically not saying that it's financial because there could be something else. For example, on the power of attorney, that's the document you need to help your parent apply for Medicaid. You, even though it's not necessarily financial and you think Medicaid has to deal with healthcare, but really it's an administrative task. And this is what you need. This is also something you need to help mom pay her bills. This is something that a validly executed power of attorney with correct powers in it, you can bring to court, to bank, and the bank will review and accept, and then give you access to the checking account or whatever the case may be. In every state, there is such a thing called statutory or non-statutory, meaning you can have a non-statutory means it's not prescribed by law, and you can just a power of attorney in New Jersey may look very similar to Florida, as long as they don't recite the specific laws of that state. You can just change attorney, the power of attorney of New York or Florida or New Jersey or other states. But again, your local practitioner will know this. One thing to keep in mind for New Yorkers is that we have a statutory power of attorney. It's very specific. It's laid out in a very specific way. It's been around for about 16, 18 years now and it has certain permutations. The last one was June 13, 2021, and it's still in force. And even though the law permits that you actually use non-statutory one that you can write on a napkin, the third party that you want to accept it is free to reject it. The statutory power of attorney is something that, if it's valid, they should accept. Now, living will, we discussed, this is the end of life document. And the healthcare proxy is what's called, in different states, it has different names. Healthcare proxy is a very New York thing. In other states, it may be called a durable power of attorney for healthcare or healthcare power of attorney. You will hear those buzzwords. It's usually in there. These are very important documents, even though no one talks about them. These are the documents that you need during your lifetime if your mental state declines. This is specifically for aging parents that can still execute these things. This is the time to execute. These are the documents, because this is what they can still use while they're alive and get benefits out of, as opposed to will or trust that, when the beneficiaries get benefit, that means this person is not with us, and in practicality, that's not something that would be important to them at that time. As I discussed, in New Jersey, durable power of attorney for healthcare. Other states may have other things, and you want yours to have the HIPAA release, health insurance portability and accountability. It's commonly and incorrectly written as HIPAA with 2 P's and 1 A, but it's actually 1 P and 2 A's. That's a little fun fact. The power of attorney, as I discussed, we have it's called the agent under all of those documents. It's called the agent. It's called an agent. Also, under power of attorney, you're called attorney in fact, and you can manage property and take care of someone's asset for their benefit. Remember, power of attorney is not a will. You're not inheriting anything while the person is alive. You have access to act for their benefit. So you cannot withdraw $100,000 from their account and escape to a nice tropical destination and then claim that you didn't know that they didn't want you to have it. This is not a gifting technique. You can have spouse as an agent, believe it or not, just saying, oh, I am the child of this person, I'm the parent of this person, I am a spouse of this person. It's not enough to just walk into a bank and say, give me access. Even if you're a spouse, a child, or a parent, you still need these documents. Without them, the person's right to privacy and attorney-client privilege and doctor-patient privilege trumps anything that you believe familiarly and traditionally maybe back in your home country or in your community should be honored. It's not going to be honored. Most likely, it's just not going to be honored. So the living will, as I discussed, it's the organ donation, the cremation versus burial. And if you want someone to fight for your life or pull the plug, that's basically what it means. And the power of attorney for healthcare is you designate healthcare agent with a proper HIPAA release. And the reason why you need a HIPAA is because you need a healthcare proxy because the doctors don't want to make decisions for you. They don't want to be then possibly sued for saying, oh, we decided to pull the plug because this person wasn't going to make it, but the family sued us because they said we killed that person and they still wanted to fight for them. So there's certain degree of information that you can, as a family member, you can get from a doctor, but under HIPAA, you can get pretty much everything that some things they might be holding back, like a very specific medical information. And you as a family member and as a caretaker will need that information to make very important, crucial life or death decisions. So you want a properly drafted healthcare proxy with HIPAA. In estate planning, we utilize the services of other professionals a lot. To that regard, in Medicaid and estate planning, it's really a trifecta. If someone has assets, you use three professionals, like an estate planner, a financial planner, and an accountant or CPA. Each one of those people has pretty much an equal share in contributing to a proper plan. So, if you have a very one-sided kind of a view that, oh, I have insurance, so I don't need a will, or I have everything in trust, or I invest everything in real estate, but I don't have a will because my kids will know what to do with it, and you haven't considered the life insurance, that is also incorrect. You have to have a holistic approach to the plan. So which means you always want to plan with your legal documents and with your financial instruments for life insurance, disability, long-term care insurance, and various other things. Specifically for long-term care insurance, if you can, you have to look into it. It's probably going to look expensive, but this is your alternative to Medicaid. Some people may have $2, $3, $5 million, and it's a lot of money, but it's not a lot if you go to nursing home. You can burn through all of that money in just a few short years with nothing left to your children. So a long-term care insurance, it's worth exploring because it may not cover it because Medicaid and long-term care insurance, wherever the provider is, they're being billed daily per bed. So you kind of want to know what does a bed cost in your area for a day, and then multiply it by 30, and then multiply it by 365, and you will come up with this number. And you want to get as close to this number as possible for someone else to cover it. And that will be either you paying cash and liquidating your assets, or it's going to be Medicaid, but only if you don't have any assets, or if you or long-term care insurance from a private insurance company. Long-term care insurance most of the time does not cover the entire cost of the bed. So for example, and this is just an example, the bed costs $400 and long-term care insurance will give you $250. You're still liable for the remaining $150. However, $150 is better than $400. So you have to plan with this. All the caretakers, please plan for this. I cannot stress this enough. Contact your local insurance agent, contact your local CPA, review the taxes, review the estate plan. If mom and dad had a will that they drafted in 1998, and then dad passed away in 2010, it's probably prudent to at least review that, because you will notice that a lot of things have changed that are no longer applicable, that are in a will. And a lot of people that are in a will may not be around. There was someone passed away, someone had a disagreement, and now the dad wanted them out of the will, but never got around to it. Only you know what your situation is, and you have to be keen to it. So special needs planning, we touched upon this. That is extremely important for anyone with a child with a special needs. The laws are there to protect these children, but there's also laws to protect creditors like Medicaid for all of the things that they provide to this child. It's extremely important. It's to make sure that this child is provided for. And a very common misconception, we see this all the time, where we have couples with special needs kids come in and they say, I don't want to spend whatever you guys charge for this. I would rather have 3 jobs and sleep 2 hours a day, but I'm going to provide for the child. And my answer is always, okay, well, that sounds insane, but it's your right. But tell me this, you're now 40 and your child is 20. What happens when you're 60 or when you're 80 and your child is 60? Can you take care of them the same way? And the answer is no. You will need to take care of yourself. So you need to plan for this immediately. That may include because the child has special needs, and if they're developmentally disabled or they have diminished capacity, they're not going to sign any documents for themselves. So you may have to do that. You may need to want to establish special needs trust, probably utilizing some of your assets or insurance products or financial products. You may need to establish guardianship, because once the child emancipates and they're 18, they may need something or want something, or you will need this, because remember, they can't sign their own power of attorney or healthcare proxy. You need to sign it for them, and that is done by guardianship through a court. There's a letter of intent, which basically means if everyone who knows and cares for the child passed away or is not able to act for their benefit, there's instructions. This child likes music and dancing, and every Thursday they go out for ice cream. Things like that, even though they're trivial, they're not. It's very important for the child. The special needs trusts specifically have are utilized to preserve public benefits that the child is receiving. As I said before, if the child inherits $1 million from someone and the money goes in outright, Medicaid takes position that, look, they have assets. You spend your assets, come back to us, and we'll pick up. Medicaid is a secondary payor. It's not a person's right. It's a privilege to have Medicaid. And it's very important that we are respectful towards the system. It is there to pick us up and not leave us homeless, but at the same time, it is very important that we respect it and we respect the benefits that we have. So a special needs trust is very important. Quick note on first party versus third party. A first party trust is a child, for example, a child wins a settlement. They were as part of a personal injury, which led to their disability. That's their money, and it's planned a very specific way. And the trust will have a Medicaid payback provision that will say if the child passes and then there's money, Medicaid is to be reimbursed to the extent that possible. And if there's money left, then that goes to beneficiaries. Third-party trust, which is what the caregivers of the child, like parents, should look into, is when you set up a trust for the child that should outlive the parent themselves, that is funded for the child's benefit for the time when the parent cannot take care of them. This means that the money is never going to touch child's hands, and they still get their all of their benefits. But if they need something extra, the money can come out of the trust. Like, for example, if Medicaid covers routine teeth cleaning twice a year, that's great. However, if they might not cover $15,000, $20,000 dental work, and that's where the trust fund comes in to ensure that this person is afforded the highest quality of life. The guardianship, again, authority to decide. This is where once the child emancipates, they're 18 and they're adult. And so you would have to go back to court and prove to the court that this child cannot take care of themselves, or an adult who declines, or the possibilities are endless. Sometimes, there's been a lot of cases during the pandemic where people being in isolation, young people and middle-aged people, 20, 30, 40, have declined. They were functional and now they're not. And you need to go to court and prove to court that, Your Honor, as much as it pains me, I need to take this person back under my wing and essentially make them again my child so I can take care of them. Same thing happens when it was elderly who are stricken with dementia and did not execute the power of attorney and healthcare proxy. This is your second second bite at the apple. The courts absolutely hate to grant guardianship if there's a valid power of attorney and healthcare proxy in place. However, we have gone to court with a valid power of attorney saying that, Judge, this person 10 years ago executed power of attorney willingly, but now they are stricken with onset of Alzheimer's, which makes them, which heightens their maybe, I don't mean to be disparaging, maybe paranoia, and they're no longer trusting their own agent, but otherwise they don't have anyone else, and their wishes wouldn't have changed. So if you prove that to court, the court may supersede the power of attorney and grant guardianship, because power of attorney is voluntary. If you grant someone power of attorney, you remain an adult able with all of your rights, and the other person can supplement that. Guardianship means that they strip this person of their right and basically make them your child. That's why you become their guardian. You also want to ensure that you have successors, just like executors and successor executors and in the will and successor trustees. You need successor guardian because you may go to court and petition, but what if you're now taken for work on a different continent, or you have your own problems, or you're stricken with your own medical issues, and you can no longer carry this out? You always want a succession in place. The letter of intent, as we discussed, there's a it's not legally binding document like the other documents we've discussed, and it just gives a general overview. Most of the time, it's not needed if the family is huge and everybody cares, but sometimes that's not the case, sadly. And in that case, we kind of want to make sure that if the third party, like a nonprofit taking care of persons aging or disabled persons, they know, at least they know some basic information about this the person we're trying to take care of. That pretty much concludes our presentation, and this is us. You can always find us online. We have 2 offices in New York City and Hackensack, New Jersey. We also have a satellite office in Brooklyn, and you can always reach us by emailing us or calling us, and we'll be very happy to discuss with you your specific situation. Thank you very much.
Thank you so much, Vlad. I'm sure that few, if any, of us on the call are legal experts, so this was super helpful and super informative. If someone is not located in New York or New Jersey, can you speak to what you might recommend for them if they have questions or needs?
Yes. So they can actually always reach out to us because we have an extensive network of other professionals that do this and other, practice in this or other areas of law. The idea is that why we do this is we're trying to take care of people. We're trying to take care of, no one should be coming in and going, you know what? And we're trying to not to say we can't help you. We're trying to say, if you're in Maryland, we cannot help you with this. However, we have an amazing vetted professional we work with in Maryland. Here's their contact information. Please go there. You need help, because we do not want to deter people from saying, well, I called Vlad's office in New York from Maryland. He said no, so I guess I'm just going to die without paperwork. We don't want that kind of attitude, which sometimes actually happens. So we always take care of whoever calls.
Gotcha. One follow-up question, and then if there's anyone on the line who has questions, please feel free to either unmute yourself and ask or put it in the chat, and I'm happy to ask Vlad. So Vlad, for context, as you know, with CareCopilot, we work with families one-on-one to find attorneys like you, or maybe find an assisted living community that takes Medicaid, or find a pain management specialist in someone's hospital network. And something that comes up relatively often with the families that they work with is families know that Medicaid would cover a lot of services if they could get Medicaid, but their loved one makes just a little bit too much in order to qualify. And so I was wondering if you could speak a little bit to how you work with families in that situation, because I know that there's some special things in New York, some other things in other states. Can you just touch at that at a high level, because we see it so often?
Yes, absolutely. By the way, I am sorry I did not mention this earlier, but CareCopilot is an amazing resource to anyone, really. We highly recommend everyone to get in touch with CareCopilot because, as Alyse pointed out, she's very instrumental in reaching out to other professionals and being able to help everyone also. So Alyse, you're doing an amazing job every day. So I'm sorry I didn't mention that earlier. That's my oversight. But to the point of resources, again, it varies so much. For example, to qualify for Medicaid, I practice in New York and New Jersey. If someone has, each state has a specific amount of income you can have in order to qualify for Medicaid. If you have even $1 more, you categorically are not able to join unless you implement some kind of techniques. In New York, we have what's called a pooled income trust. And that is a nonprofit that's authorized by the state of New York. There's a lot of them out there. Not all of them are created equal or provide the same services. So we can always also give you kind of a heads up on which one is better than the other without being an endorsed speaker for them. We just have experience with a lot. And there's some of them that we work with. But so that's a technique, and they will hold the excess monthly income and pay your bills. In New Jersey, there is no such thing. The New Jersey is a qualified income trust, and it works completely different, and it's a completely different rules. And the levels of income are different. Same thing goes for look back period. New York, as of now, does not have a look back period for community Medicaid, but they have 5-year look back for nursing home. New Jersey has 5-year for both. So if someone declined now, you still can't get Medicaid. You have to spend down the assets. And this is very, very important. And I think the New Jersey actually is very similar to most of the other cases, other states. So, and then there's various degrees of estate recovery. It varies by county. So you need a proper planning, and only a practitioner in your state, but preferably in your county or the neighboring county, will be able to address. Because even being in New York, I would never be able to, even if I traveled to Erie County, that's right under Canada, 8 hours from here, it would be the same rules, but the Department of Social Services there would work differently, and I would not be comfortable doing that. But here in New York City, the 5 boroughs, Rockland, Nassau, Suffolk, that's a fair game. And they also could not be more different from each other, how they administer the same laws. So this is where it's very important to go to someone who is literally in your wingspan. So being in Manhattan, I can meet with someone in the Bronx or Staten Island, but I'm not going to Albany.
Yep. Gotcha. Makes sense. I think we have time for one more question, and there was one more question that came to me via direct message. She sent the question, and then she provided some context. And then I think we'll be a little over time for David's question, but if you can stay on for a few minutes after Vlad, maybe we can answer that as well. Yep. So the direct message question that came to me, I'll read the question and provide the context she shared. She asked, does someone need to be officially or legally declared as having an impaired capacity in order to activate the power of attorney? So the context that she provided is she's the agent and attorney for her mother's power of attorney. The mother established the power of attorney in a will and a trust a while ago and was recently diagnosed with Alzheimer's. So this individual is wondering, does she need to tell the attorney that drew up these estate papers that the mom now has Alzheimer's? And if she does, what impact would that have on mom?
Technically speaking, if these documents are properly executed and withstand the test of time, they can be used even 20, 30 hours later, years later. The whole point of these documents is to have something that is probably state of the art at the time they were drafted. Think about this in a different light. When Windows XP came out, we all rejoiced because it was so much better than everything else. And it worked. Would it work now? Maybe on some machines. But would we install it now? We would not, because we're light years ahead from there. We had so many different permutations of the Windows. Same thing with the documents. It might still be operational. For example, if mom said, I appoint dad as my healthcare proxy, and if dad cannot serve, I appoint my daughter. In the meantime, between then and now, the dad passed. The daughter can go in automatically as a successor agent upon proving to whoever wants proof that dad passed. So this is why you absolutely want succession, as we discussed for guardians. So the documents stand. If they were properly executed at the time of execution on a proper form, they will be grandfathered now. However, as we have seen with power of attorney in New York, The latest permutation before 2021 was around for about, I would say, like nine years. From 2012, it did change from in 2008, and then again, and then again. 2012, we used it for a while until 2021, it was revised again. If it was executed on a proper form in 2016, it still should be accepted now, even though the new form is there. However, if we take a 2012 form and execute it now, it's probably going to be rejected because it's not valid. So also you have to look at who are the people here, who are the agents. If it serves the purpose, it serves the purpose. Fantastic. Do you have to tell this to your attorney? If you're satisfied, then no. I don't have a lot of clients coming in every time something changes but I have a lot of clients coming back saying something major changed. There's a major life-changing event like birth, death, incapacity, moving to a different state, which is really a lot of people are not looking into. I had a meeting with a fantastic client, someone I've known for many years. She worked with my parents. And then she retired and she said, Vlad, I always wanted to talk to you. Let's meet. So we met and it was great. And she said, oh my God, I meant to talk to you about the will and the trust for a long time. I said, fantastic, let's talk. And she goes, I am moving to Florida next month. I just retired. Well, that's the end of that conversation. I'm like, I'm not licensed in Florida. But she said, but I really trust you. I really want you to be my lawyer. Can't you do a Florida document? And my answer was unfortunately no. I recommended another attorney that I work with closely in Florida, in the county she's moving into, and it was all taken care of, but I couldn't. So, but if the client does have a concern, they can absolutely come back to their lawyer. We highly recommend that all these documents are at least dusted off and reviewed by the client at least annually. And then, every couple of years, you can schedule an appointment for meeting with the lawyer to review the documents and discuss the situation and really see if anything changed.
Gotcha. Thanks so much, Vlad. For the individual who asked, if you have any follow-up questions, let me know. In the meantime, we are at time, so if you have to hop off, feel free. But for those who want to stay on, I will get David's question answered by Vlad. So Vlad, David asked if you could confirm what the monetary amount is that separates a small estate versus a large estate. And he made the comment that he understood this to be about $20,000. And I'm not sure if I'm understanding this correctly, but small estate and probate, I'm not too sure.
Yes, I was thinking about that. That's what his answer was. This is something we didn't really touch upon, but the monetary amount, again, varies by state. So New York used to be $20,000. It's now 50. And what it does is there's what's called Article 13 small estate, and then there's a full estate. So a small estate is designed for collecting the assets that are relatively small. That's why it was $20,000 for ever and ever. And now it's 50 because even 50 is considered small. And this is something that you don't need a lawyer for. You go to court, the forms are simpler, but the catch is that you have to know pretty much how much money is there and where it is. And it's usually small estate. It usually only works for someone with just a small bank account. Mom was on Medicaid and she had $7,000 in Chase when she passed. We know the Chase branch here and whatever the case may be. That's a small estate. So the court directly allows you and says, Mr. X can go to Chase and collect $7,000.50. Anything else is not. Anything that's complicated, even if it's less than 50, will go through the full estate. For example, if mom had immigrated from a European country or anywhere else, and she has an apartment that's, I don't know, if she has an apartment in Moscow and it's $20,000, it's under 50,000, but it's a different jurisdiction, which will require a ton of work and a lot of real estate and other involvement. That is not a task for a small estate. Even with that, they will need a full estate. If it's just cash and it's under 50, 49,999, that's fine.
Excellent. Thanks for clarifying. $20,000, even $50,000 sounds like a lot of money to me, but I get it.
It's a lot of money, and a lot of people, and actually pretty much for everyone who is doing the small estate, that is a lot of money. It's mom's entire savings. And you know, but actually, if you you probably know this, that New York used to have this for single like 16,000, and they just went straight to 30. Because of that, also there was a large increase in fees that otherwise were just being increased. Small, like the $20,000 small estate was not increased for in many years, and Medicaid savings, how much a person could have, was increased only. The limit was only increased by about $400 or $500 a year. So 12,000, 12 and a half, 30,000, and it went from 16 straight to 30. So there was a kind of a reform.
Gotcha. Last call for any questions for Vlad. Again, thanks, Vlad. This was super informative. I've put the link to Vlad's website in the chat so that folks can get more information. The link to CareCopilot is in the chat if people would like more information. As a reminder, as a part of the HFC community, you get CareCopilot for free, so please take advantage of that. Any last questions for Vlad before we let Vlad go here?
I guess I'm that amazing that I've answered everybody's questions. But I urge everyone, especially if you're in New York or New Jersey, you can reach out directly to us. And if you're in another state, we will be happy to connect you with another professional. And obviously always reach out to Alyse. She's amazing.
I think I might have heard someone come off mute there for a second. Maybe not. Okay. All right. Well, everyone has Vlad's contact information. Definitely get in touch with Vlad. I have forwarded some CareCopilot clients to him, and they've been happy. So if they're happy, I'm happy. And yeah, thanks again, Vlad, and have a great rest of the afternoon and evening, everyone.
Thank you so much for having me.
Bye, folks.
Thank you. Bye.